so I'll just report various categories under IPR and how it is important for the startups. Okay.
Also, education. What investors look for in your startup. The first point, what is the intellectual property?
Okay.
This is connection with
So I'll be quickly briefing about the various IPs and also what are the requirements for filing the IP registrations and also what is the benefit that you are going to get out of registration and I will also highlight some of the example. And one more important aspect is for the techno entrepreneur. See, you identify some gaps and you come out with some solution. Okay, to finding some solution or maybe modifying the existing products. Okay, so that information you can get through the patent research. Okay, so that is also one more important area where the technopreneur should really should go through that information. Okay, so first I'll brief about the various search. Okay, so that will be helpful for you to see what are all the latest technologies that are happening in that particular area and who are the players in that particular area, who are the persons working in that particular area, and you can also find out what are the companies focus. Okay, so what are the countries where they are focusing on. Okay, all such important insights you will get from the patent search. Okay, so that I will highlight and I will try to finish off by 4:45 like that. Okay, uh, so coming to intellectual property rights, intellectual property is an intangible asset. It can be anything. It can be any creativity. Okay. It can be any product. It can be any artistic work. Okay. Anything that you create original. Okay. So with your intellect, whatever you create. Okay. So that comes under intellectual property. Okay. So when I'll give an example. Whenever you purchase some flat or land, you immediately go for registration, right? So why you do that? You want to own that property. Okay, you want to claim that it is your property. Okay, and if you are not staying in that particular flat, okay, you sell it or you rent it. Okay, in return you get the revenue. Okay, you get rent for that. Okay, so similarly, whenever you protect your intellectual property, you can generate the revenue by giving the rent, I mean by giving licensing or by selling that particular property to any other. Okay, so that is the advantage of having the intellectual property. Okay, so intellectual property, there are various categories under that. Okay, first we will be discussing about the patents. So this about our IPFC, but then intellectual property I've already told. It's an exclusive right which mainly protects the inventions. Okay, that are created by mind and it is given for a certain period of time. Okay, and these are there are various categories. And before that, we have to understand why actually this intellectual property law is being implemented in India. Okay, so earlier you all aware of this WTO. Okay, so WTO mainly facilitates the trade between different countries, and India is also a member of this WTO. And there is an important agreement called TRIPS agreement. Okay, so trade related aspects of intellectual property rights. Okay, so this particular agreement says that for every member country, it is a mandatory to implement this intellectual property rights. Okay, that's how India also started giving protection to all types of intellectual property. Okay, so that's why we have plant variety protection, we have service marks protection. Okay, earlier we don't have such things, and there is no protection for the product patents, especially in the case of pharmaceuticals. Okay, earlier, but after implementing this TRIPS agreement, all this been started implemented in India. Okay. So there are various categories. First, we will discuss about the patents. And the patents is a right, exclusive right given for any new product or a new process. or it can be for the improvement, okay, which has some economic significance. Okay. So any product suppose which you observe in the market, if some startup has coming out with some improved version of that particular product by adding some more features, or maybe it has more cost advantage. Okay. Suppose they are able to sell that particular product at a low cost. Okay. Changes. Okay. So all those things can be protected under patents. Okay. So patent is given for new products or a new process, or it can be given for the improvements. Okay. And it is a monopoly right. It is given to an individual, it can be given to a company, it can be given to an institute, okay, where this research has been done and some innovative product is being. So it can be a joint applicant also, okay, an individual with some company can also apply for a patent, okay, and this is given for 20 years period, okay. Suppose today you file the application, from today to 20 years you will get the protection. Okay. So the main criteria, there is certain criteria for getting the patent right. Okay. So the three important criteria is first is novel. It should be new to the entire world. Okay. Whenever you create something, you may feel that it is very unique idea where no one has done it. But when you go through the literature, you will get to know what actually some other country somebody is maybe doing that, producing that particular thing. Okay, already this information is in the public domain. Okay, so that's why whenever you invent something, you first go through the information and see whether it's a novel thing or not. Okay, and the second is inventive step. Okay, so there should be some technical advancement. For simple things, patent will not be granted. Okay, and third one is industrial application. Okay, so anything that you invent, okay, it can be a product or process which should be used by the industry, okay, and made by the industry. Okay, so these are the three important criteria for getting the patent right. And apart from that, there is also certain things where India doesn't grant the patent rights. Okay, that are all non-patentable inventions. Um, one is frivolous inventions. I may say that I have developed a machine which is 100% efficient. Okay, no such thing will be there. Okay, so traditional knowledge. Okay, see, our ancestors have given a lot of knowledge, and that is in the public domain. Okay, so that cannot be patented. Okay, and duplication of machines and rearrangement of those things cannot be patentable. Okay, and in India, software is not protected under patent. Software is nothing but it is a series of logical expression which is protected, which is treated as literary works. Okay, that's why it is protected under copyrights, not under patents. Okay, but any hardware, any device that works with the software, okay, which is something new, okay, which meets this patentable criteria, will be given the patent. Okay, so new software cannot be patentable.
Process, say,
Process should process anything that you it should lead to a product, or it should lead to some economic significance, low cost process, but it should lead to a product.
I have a doubt, like a phone pay, which is very new, or
That-
the Google Pay.
That all
That comes
business
under
product software. Yes,
So that's not patented.
it comes under copyright. Okay. And these are given for 20 years, okay? And the main thing you have to keep it in mind is whenever you invent something, it should not be disclosed, okay, in the public domain before you file a patent application, okay? So this is an important thing, okay? Whenever you want to go for patent filing, first you file the patent and then um, sell that particular product or disclose to any other investor. Suppose you are looking for investment for that particular innovation. Okay, first you file the patent application and then disclose to your investors. Okay. Yeah, it should be applied first. Okay. And India follows first to file system. Whoever files first, they will be given priority. Okay. So that you have to keep it in mind. And one more thing is patent It's a territorial right. Wherever you want to protect it, you have to file in that particular country. Okay, suppose your product you have already filed in India and you want to export to any other country. Okay, you want the protection there also, then you have to apply for the patent in those countries also. Okay, so wherever you need, you want protection, you have to file individual in those countries. Okay, there is no worldwide patent. Okay, wherever you want, you have to file the application. Okay, and there is also one more system called international filing system provided by World Intellectual Property Organization, and that is called PCT, Patent Cooperation Treaty. Through this, you can file an international application. Okay, with which you can enter into multiple countries in a cost-effective way. Okay, so that is one system where you can enter into multiple countries. Okay, there are 163 member countries to WIPO, and with a single application, with a single fee, you can enter into multiple countries. But that application has to be processed again in those member countries individually according to their rules and process. Okay, so that is one system where you can enter into different countries. Okay, and and the requirements for patent filing is there are two types of applications. One is provisional application and second is complete specification. Okay, whenever your invention is in the idea, maybe in the process, okay, in the idea stage, then what you have to do is you have to just give the summary and you can file the provisional application in order to protect it. Okay, and within 12 months after filing the provisional application, you have to file the complete specification and giving entire details about that particular invention. Okay, so you should not wait. Suppose you are already ready with your invention, you have everything ready and the prototype is also ready. You know that your product it is working and there is a lot of scope, and then immediately you can file the complete specification. Okay, and if you are not able to file within 12 months after filing the provisional application, you will lose that date. Okay, so that's why whenever you are filing provisional application, you have to see that you file the complete specification within that, but within 12 months. Okay, and in patent filing, all are time bound. Okay, so whenever you file the application, you have to see that you have to be very alert and you have to process your means you have to respond to the communications whatever you receive from the patent office within that particular time specified. Okay, and at every stage there are certain time limits. Okay, so within that time limits you have to respond. Okay, so that's why whenever you file patent application, you see that whatever the queries, whatever the objections, whatever the communications that you have received from the patent office, you have to respond within that particular time. Okay, and the main requirements for patent filing is in case of provisional, you just need to give the applicant details, inventor details, address, and also the invention. What is just in the form summary. Okay, and you can also give the diagram of the product or the process. Okay, but in case of complete specification, you need to give the entire details. Okay, you should give the background. Okay, means where you have to also do the search and see what are all the related references in that particular area, and you have to explain how your invention is different from those products or the process that is existing. Okay, and then you have to also give a detailed description of that particular invention. Suppose if it is a product, you have to give the details regarding that particular product. Even the minute details of that invention should be mentioned in this particular document. Okay, so whatever you disclose, for that you will get a protection. Okay, so you should not hide anything. Okay, anything that you feel that it is very important, and you should disclose that particular information in the complete specification. Okay, so that you can also go through the patent. It is a technical information written in a legal language. Okay, so I think most of the faculty community, they know, they are already habituated in writing papers. Okay, so they know how this paper will be, means they have a title, they have a summary, they have a background, everything. In the similar way, for the patent also, it will be different sections where you need to give the information. And the last part will be the claims where you write the invention aspects, okay, in a legal language, okay. So in case of legal issues, the court will go through the claims part, okay, what actually you have claimed, okay. Suppose in this mic, okay, this is already available in the market. I have made some improvement in this in the upper part, okay. Maybe it able to sense, okay, and it maybe it modify the voice, okay, and then it delivers, okay. So that is something invention which I have made and it is nowhere in the market, okay. So for that improvement, I file a patent application, okay. So I will talk about that improvement part only in the claims. Oh, not anything, the whole product you will not mention, okay. Just the improvement, whatever you have made, that improvement part, that is actually your invention is, okay. So you mention all that in the claims and you submit the application, okay. So this is the thing. And the government fee for the startups, educational institutes, and also MSMEs, that is 1600 rupees is the application fee, okay. And there are different fee structure for different stages, okay. But application it is only 1600 rupees, okay. And there are several stages in the patent filing. Once you file it, okay, once you file the provisional, you have to file within 12 months a complete specification, and within 18 months the patent office will publish that in the patent journal, okay. Every week the patent office will publish your patent application, and that date is very important because that is the date on which the people came to know about your invention, okay. In case of any issues or somebody has copied it, you can stop that and you can claim the damages from that particular date, okay, because that is the date on which people come to know about your invention, okay. So after the publication, there will be 6 months period open to a public where they can file an opposition, okay. So anybody who feels that that is not patentable, okay, they can file it, okay, with a proper evidence. It is not like simply just opposing, okay. They have to provide some evidences why it is not patentable, okay. And if there is no opposition, then there will be an examination stage where the examiners who are the expert in that particular domain area, they will go through the patent application and they will see technical what are the references which is available in the public domain, and they will evaluate, okay, whether this invention is patentable or not, okay. And they will issue a examination report, okay. So in the examination report, if it is a positive thing, means if it is positive, there is no objections, then it will be granted and issued a certificate, okay. No, after 12 months, okay. And if there is an objections in the examination report, okay, then we have to comply that, okay, we have to give an explanation, okay, within 6 months time, okay, why our invention is different from those references quoted, okay. So the inventor, the applicant has to give an explanation, okay. So they have to file the response to that examination report, okay. After the response also, if the examiner is not convinced, he will call for the hearing, okay. And after hearing, if they will ask for the explanation why it is inventive or why it is novel, why why the applicant feels that it is something inventive which has to be patented. Then the if the examiner is able to convince, okay, means he is convinced with explanation, then he will grant and then certificate will be issued, okay. And no application will not be refused. Any application, okay, whoever files, it will not be refused simply. There will be a proper explanation given, and also they will be giving a chance for the applicant, okay, to attend the hearing and where he can explain, okay. Simply they will not reject it, okay. So that is a whole procedure that the patent office will follow, And for everything, there is a time bomb. They have to respond within that particular time specified as per the patent law. Okay, and this is about the patent. And once a patent is granted, okay, there is a renewal fee. Okay, so for the first 3 months, we have to file the. I said no, it is from the filing date to 20 years. You have the protection. So when it gets granted, okay, maybe after 3 years or 4 years, then you have to pay the renewal fee. For the first 3 years, there is no fee. From the fourth year onwards, there is a fee. Until 20 years, in order to maintain, then you have to pay the renewal fee. Okay. So whenever somebody says, some company may come forward that they have a patented invention and a patented product. Okay, and you are investing, or maybe you wanted to take a license of that particular technology, then you have to see whether its patent is active or not. Okay, so you have to check whether it is legal status of that particular patent. Okay, so whenever you look for some technologies, okay, to take a license, then you have to see the legal status of that particular patent. Okay, yeah, there is a public search option, okay, in patent. I will show you at the end where you get all this information. Okay, so this is about the patents. Okay, so next category is
universities planning now for the students who are going to take.
okay.
That will be eligible only as per 2 or 3 years. After 3 years, every year university will pay.
And that is why you should have an IP policy. University should have an IPR policy. Suppose when you are supporting the students, you have to have certain agreement with the students that after a certain period, okay, it will not be. They have to maintain. Okay, so that type of agreement. All this will be mentioned in the IPR policy of the university. See, for the first 3 years there is no fee. For the fourth year it is 800 rupees. Fourth, fifth, and sixth, and from seventh again 2004. As the year increases, the fee also increases. Okay. So most of the companies what they try to do, so especially pharmaceutical companies, they look for the patents which are going to expire because they wanted to see that and means they wanted to manufacture that particular product. Okay, or a drug. Okay, so they go through the patent information and then see that what are the patents that are going to expire. Okay, and then start preparation. Okay, so that is a very big business of generic drug manufacturers. Okay, so
But recently, any patents are issued in India under your
yeah, SNR Transformers, that is a company where we have filed two patents. It is a cast iron transformer, which it is means compact transformer, and that got patented. And one more is for CIT, Center for Tool Design, where we have filed three patents. Okay, it is also under MSME ministry, where we have filed a joint patent that is between CICD and the standard fireworks. It is an automatic machine for production of conical fireworks. Okay, so it is a pneumatic machine. So which has automated the whole process of manufacturing the conical fireworks. Okay, so that also got the patent. And one individual from Nellore, where it is fuel saver. Okay, that can be used in automobiles. Okay, so by using that component, there is some advantage of having fuel efficiency. Okay, and it is also eco-friendly. Oh, I mean, sorry, environment. It addresses the environment concerns. Okay, so that also last month we have received the patent. Okay,
granted.
yeah, granted and certification. Yes, granted. Okay. So likewise, we have also filed so many patents from the individuals. Actually, one person from Guntur. Okay. He has invented a drying machine for agri commodities. Okay, especially for spices. Okay, like chili. Okay, so that also we have filed patent application. It is about maybe in 2-3 months it will be awarded. We have responded to the examination also, that was positive, so it will be awarded. So likewise we have support facilitated around 50. Okay, but in the case of trademarks we have filed more, because most of the small companies look for trademarks only, not patents. Okay, and that is about the patents. Now I will quickly brief about the trademarks. And trademarks mainly protect the brand names. Okay. So any mark that represents your company. Okay. Products or services. Yes, logos, any graphical design, captions, logo. Okay. Anything that represents your company identity, that can go for trademark registration.
It's not copied by anybody.
Yes, and if they also misuse, then you can take an action. Okay. So it is given for 10 years period, and you can renew it for n number of years. And the government fees for filing the trademark is 4,500. Okay. And this is for SME startups. Okay. And then trademarks, there are you need to there are also criteria. Okay, not that all marks gets the trademark. Okay. So any mark, any branding when you are choosing, it should not be identical or similar to the existing trademarks, and should be easy to pronounce, unique. Okay, and it should not be descriptive of the product or services that you are offering. Okay, so most of the entrepreneurs they choose a brand which is of descriptive nature. Okay, but actually to get the trademark registration, it should not be a descriptive of what you are offering. Okay, so that you have to keep in mind. Okay, and even India also recognizes well-known marks. Okay, even that company, okay, well-known brand, okay, it is not registered in India, but they are very popular. They are known in the public. Then still, any mark which is similar to that cannot be registered. Okay, for example, Amul. You know, Amul is a very famous brand. Okay, some company, I think they wanted to register as IMO. IMUL. Okay, it's only a spelling change, but phonetically it is similar. Okay, so that also it cannot be registered. Okay, but there is also one more criteria. Suppose I have been using, okay, the mark is a descriptive nature, but I have been using that particular brand for several years, maybe after 25 years or 30 years, I got some recognition. Okay, it has acquired certain meaning. Okay, so people identify that brand. Okay, because you have been spending means spending on the advertising, or you are being selling that particular product with that particular branding. Okay, for several years. Okay, people recognize that brand. On that particular thing also, you can apply for a trademark, provided you provide some evidences that you have been using for several years. Okay, and person names, geographical names, okay, descriptive, generic words cannot be given the trademark. Okay, and even logos, captions, everything can be protected under trademark registration. And as I said, 10 years essentially, and you can renew it for 10 more years. Okay, again after 10 years, you can renew it by paying the renewal fee, then you can extend the term. Okay, so that is about the trademark. And trademarks you can also file online. Okay, it is not mandatory to go to the trademark office and file it. Okay, everything now online. Okay, and there are 1 to 45 classes under trademarks. 1 to 34 is goods mark, and 35 to 45 is a service mark. Suppose your company is into pharmaceuticals, okay, it falls under class 5. If it is relating to confectionaries, okay, it falls under class 30. Okay, suppose if it is an institute, okay, training institute, it falls under class 41. Okay, so we have to identify the class under which your product or service falls, and then you have to file the application in that particular class. Okay, so for each class 4,500 is a fee. Okay, so when your company is offering 2-3 products in different segments, then you have to identify the class, and then you have to file the application in that particular classes. Okay, so that is about the trademark. Okay, and
But it's
no
not patent.
patent. For trademark, it is not like that. Suppose you have been using that particular brand for several years, and now you feel that it became famous, and you want to expand your business into other areas. Then you can file that and also. Okay, it is not mandatory. First, you have to file and then. Okay, even if you have been using, you can still file. Saver. Mm.
Masha.
You cannot apply for the patent.
Namaste.
First, you have to category is industrial design. Yes. It is territorial. Okay. Again, you have to file in other countries wherever you want it. See, there if you have not protected, it is acceptable. That's why wherever you want to sell your product, you have to, and you can go for international filing also. There is an international trademark filing through matter system where you can protect in all member countries, almost 93 member countries of the Madrid protocol, where you can get the protection with a single application. Okay, so most of the MNCs make utilize of that system, and they file in different countries with a single application. Okay.
No, but see, I think there's a very important question is raised. Uh, you filed a trademark in India, or your friends who wanted to file a trademark for the same thing in other countries. Okay, that's what the question is.
No, already been using. He told that already he is using in other countries.
Example, KFC, ma'am. KFC has come from another country. They have filed the patents and the copyrights and trademarks over there. Somebody has now got it to India and somebody has again started on the
No,
same
they
KFC.
have the protection before entering into different markets, and they give
No,
franchise.
example.
Okay,
No,
so
example. Between the two friends, example, I'm just telling, like, if the same name, if though they are, it's not a franchise and all, they are just two friends who has copied an idea in that particular case. There are two friends.
Yeah.
Yes, one fellow is doing a business in India, and the other one is doing the same business with the same product and all with the same name in the other country. Can he file over there?
you
Yeah,
cannot
that's what
file.
see, you have to remember getting a IP, there is a three criteria Madam said. Novelty, inventive step or non-obviousness, and industrial use. This is applicable to all types of ideas before they are granted. So when he files a application in the other country or friend, for which already a trademark protection is available in India, but whereas it is not there for you. So when he applies there, the examiner there will see for the novelty whether this trademark is in use anywhere in the world. Okay, that is what they call absolute novelty. Absolute novelty in the sense it should not be in public domain at all anywhere in the world. Okay, the examiner will check for that point before granting a patent whether similar kind of trademark or a patent is granted anywhere in the world, though they may not have protected, but it should not be in operation, in existence, in use anywhere in the world. If that is there, the examiner will reject it. That is what we call absolute novelty check. You know?
And there is also one portal which is available provided by WIPO. There is a brand database. Okay, you can check for all the brands that are for which the trademarks have been filed. Okay, so global brand database. You can check what are all the brands that are already registered in that particular portal. Okay, and so main advantage of having the trademark registration is you can take an action against the people who are trying to copy or misuse your brand name. Okay, you can also expand your business in other areas. Okay, you can suppose you are operating only in one state and want to expand in other states. You can look for the franchise. Okay, you can give franchising and then you can expand. Okay, and you can also sell it. Okay, like how you sell your other properties. Okay, so that is also one thing. And for nowadays everyone is marketing their products and services through online. Okay, through social media. And for that also there is an important requirement that if you want to sell your product on e-commerce platforms, then you have to have a trademark registration. Okay, and there is also one more portal that is called GEM portals. Have you heard about this? Government e-marketplace. Okay, so this is a this is a site where any seller and buyer can register, and most of the government organizations, okay, PSUs, will have to procure the products through that particular portal only. Even our institute, whenever they want some requirements, okay, like if they want to purchase furniture, okay, they have to purchase through that particular portal only. Okay, so if they have the trademark registration, they can, any company, okay, manufacturer, they can register under that and they can supply to the government department. Okay, so that is one advantage. Okay, uh, and if any misuse, somebody copied or they have changed little bit and they are trying to sell that particular product. Okay, but they are creating confusion because the brand simple modification they are doing and then just selling that. Okay, so they are taking the advantage of your brand name. Okay, so those activities also you can immediately stop by sending the legal notice. Okay, and you can also claim the damages the what that has happened. Okay, immediately you can seize their products, you can send a legal notice. Legal action can be taken if you have the trademark registration. Okay. Yes, and this is see when the registration is done. Okay, it is the applicant who has to take, who has to enforce his right. Okay, suppose somebody is copying and the applicant is simply not taking any action, then nobody can help it. Okay, he has to use his right. Okay, and he has to use it properly so that he can generate the business and any illegal activity or counterfeit products are not entered. Okay, yes. And next thing is copyrights. And copyrights mainly protects the expression of your ideas. Okay, it can be literary works, it can be an artistic work, it can be a music, anything. Okay, so even software is protected in the copyrights, and they have the longer period of protection, like life of an author plus 60 years. Even the author dies, his legal representative will have the right over it. Okay, and it mainly protects the expression. Okay, not the idea. Okay, suppose I have an idea, I express in some form. Another person also have the same idea, but he express in a different form. Okay, so both the expressions will be protected under copyright. Okay, and next category is industrial design. And for copyright, there is a copyright board in Delhi. Okay, and the fee structure for literary works is 500, and for software it is 2,500. For the music and films related is 5,000. Okay, so we can apply through online application, and whatever the book, suppose if it is a literary work, you have written some book. Okay, you have to submit the 3 copies of book to the copyright board. They will do the plagiarism check and they will see whether it's original work or not, and then they will issue the certificate. Okay, And for copyright also, it is not mandatory that you have to go for registration. Still, if you don't have the registration also, still under common law you can fight it. But in the court, you have to prove that it is your work. Okay. If you have the registration, it will be very simple to prove it. Okay. So that is the advantage of having the copyright registration. Yeah, that also. But if you have a valid certificate, that also you have to show no whether it is your work or not. That also. That's why it is better to go for registration. Okay, and it is very minimum cost, only 500 rupees. Okay, and next category is industrial design. Industrial design mainly protects the design aspects. Okay, so any design, okay, new design that is applied to a product. Okay, so that can be registered under industrial design. Suppose for this particular chair, I have designed a new fan. Okay, so that can be registered. Okay, so that's how most of the consumer products. Okay, like even for the kids feeding bottles, each company come out with a different design. Okay, and even toothbrush. Okay, we see different companies come out with a different design. Footwear, jewelries. Okay, textile design. All this will be protected under industrial design. And industrial design mainly protect for 10 years and it can be extendable for 5 more years. So total 15 years. And this is very much helpful for the small companies, okay? Because they cannot invest money in the product development and all that, and they don't have resources to do all these things. Okay, but for simple fact and simple designs, if they can improve and they can have the IP. Okay, so that is the advantage of having the industrial design. Okay, so all these products go for industrial design. Even the design of a set. Okay, please tell IKEA. You know, IKEA protects all their designs under this category. And next is geographical indications, and this is something which is different from other category because it is not an individual right; it's a collective right. It is given to an agriculture products, industrial products, food products, which has some unique characteristics, which is linked with the geographical location. Okay, in AP we have Tirupati Laddu. Okay, so it is very famous and it has some commercial value. Okay, so any product which is linked with the geographical location as having some certain unique characteristic, so that can go for GR, and it is not an individual right; it is a collective rights. Okay, it mainly helps the community development. Okay, rural development helps the artisans. Okay, so for those type of products, you can take the geography, and it is similar to the trademarks. Initially, you get the you can protect for 10 years, and you can extend for 10 more years. Okay, by paying the renewal fees. Okay. So in India, we have more than 600 GI registered already. We have 500 more applications which are filed. Okay, so all the traditional products. Okay, like in handicrafts and handlooms, we have lot of products which are already registered. Okay, so whenever you are purchasing some GI product, you have to look for this logo, and this is an authenticity. Okay, so this is a common logo used by all the GI products. Whenever you go some exhibition and want to purchase some handloom, okay, especially Venkatagiri, Gadwal, all these sarees, no, they are all GI products. Okay, so look for this tag. Okay, so this is an authenticity that these products are original, originated from that particular place. Okay. Yeah. So whenever you have this GI registered, you can fix some premium price. Okay. Because only that's how the weavers or the artisans get the benefit. Okay. They can fix some premium price when compared to the other products. It depends upon the market potential of that particular product, and you see now Pochampalli sarees after getting the GI, a lot of variation now. Minimum simple saree, it is costing around 5,000 rupees. Okay, and then there is also opportunities. Okay, they also tied up with Fab India. They also patent solely, and they're coming out with new products. Okay.
Also, it is very important if you want to export, unless you have any of the protections of intellectual property right, many global stores like Amazon and all, they don't accept registration of your product in their portals. IP is so important.
And there is also special provision given for the GI products in gem portal and also in social media sites like Amazon, Flipkart. There is a separate promotion is being for the GI products. Okay. The next category is layout design for integrated circuit, and this is mainly used by the semiconductor industries where they use some unique design for the circuits. Okay, so all these, if any circuit design, new circuit designs have been developed for certain application, they have to file the application in this particular category, and it is given for 10 years period. Okay, so in this case, we have very few applications. Okay, so very few applications in India. Okay, a lot of awareness has to be bought in this particular area, and hardly around 1,000 applications received. Okay, which is being registered. Okay, and there is also one more category which is applicable for the agriculture sector, and the plant variety authority is going to grant this particular prize, and it comes under Ministry of Agriculture. Suppose any new variety of crop is being developed. Suppose in case of rice, we see a lot of rice varieties. No, if somebody has come out with some new variety of rice, okay, so it can be protected under this particular category, and there is a test performed that is called dust test. Okay, they will not issue immediately the certificate. They will test this. Okay, under certain criteria, and we have 43 dust centers. Okay, all over India. Suppose if it is rice variety, then it will be sent to rice Institute of Rice Research. Okay, in Hyderabad, where they have a dust center, and they will cultivate that, okay, for 3 consecutive years, and they will see, observe the results, okay, whether it is distinct, uniform and stable, and based on that they will send a report to the plant variety authority where they will be issuing the certificate. Okay, so this is a very lengthy process. Okay, it will not be granted simply. Okay, okay, the time period is 15 to 18 years. In the case of crops, it is 50. In the case of trees and vines, it is 18 years. Okay. And other category is state secret. This is something different from all other categories. Here we need not disclose to anybody. We keep it secret for ourselves. Any information that you feel that it has some commercial value, okay, so that will be kept as a trade secret. And India doesn't have a strong enforcement laws for protecting the trade secrets. Okay, so it is applicant. I mean, it is the owner of that trade secret who has to keep who has to take certain measures in order to protect it. Okay, so once it is leaked, we no more you cannot take an action also. Okay, and in one product we can expect n number of IPR rights. So like we have in a CD player, when it was first invented, it is protected by patent. Okay, its brand can be protected by trademark. The design can be protected by industrial design. Okay, the music that is being played and which is something new music which is composed, that is something comes under copyright. Okay, so mainly IP helps in preventing the competitors from copying or closely imitating, and also it attracts the investment. So like VCs and the angel investors, they always look for IP protected products or inventions. Okay, and it also helps you to expand your market by licensing or franchising, and it also increases the market value of that particular company. Okay, so whenever you have some IP for your product, then your company value will be more. Okay, and lastly, with a simple example, I want to highlight, see, to show how IPs work. Okay, so this inventor, this is a lead opening technique, which is invented and taken a patent, right? And the inventor has given a license to a Coca-Cola company, okay, for 1/10 penny per can. Okay, during that validity, the inventor has earned 1,48,000 UK pounds a day on royalties. So that is the worth of having the patent right. Okay, it is simply registration will not fetch you any benefits. Okay, it is up to you how to make use of those rights. Okay, so you have to use it strategically to generate the revenue out of it. Okay, so that is the advantage of having the IP rights. Okay, so I will show the sites quickly where you can get all the information and also how to do the patent search. Okay. Please search for patent. So whenever you are doing some research in a particular area, first you go through the patent information and see what are all the developments that has happened already. Okay. So every country has their own site for this patents. Okay. You can go through that particular site and check for their patents. Okay. Then you will understand actually what are all the developments that has already happened and where is the gaps where you can work on for getting some solution for a particular problem. Okay, and this, see, you can search by title. There are different fields. You can search by company name. You can search by the title. You can search by some keywords. Okay, and there is also one more important thing that is called classification code. Okay, so whenever you go to a library, there is a code given to a particular subject. Okay, so that's how you retrieve the book. Okay, so similarly for the patent also there is the classification codes. Okay, which is given by WIPO, and this is universally followed by all the patent office. Okay, so whenever you are looking for a particular area, okay, maybe in electronics related or agri related, okay, there is a particular classification code, okay, given. Okay, whenever you are searching a patents in that particular area, first find out what is the classification code and then view that code, and then you will get all the patents that are filed in that particular area, and that will be very much helpful for you whenever you're starting some research. Okay, and whenever you want to see what are all the companies which are working in that particular area, suppose in EV, okay, I want to see which are the companies which are filed. Okay, then you can just give EV and then you see what are all the patents that are filed in that particular area. Okay, so if you want to find out company, okay, what are the patents that are having by a particular company, then you can just give the company name and see what are all the patents. Okay, so in each country there will be a site, okay, where you can freely search for this particular data. Okay, and you can get lot of insights from this particular thing. Okay, so please go through this. Okay, and there is also application stage. Suppose you have already filed, okay, then if you know the number, you can just give the number and see what is the status of your application. Okay, if it is already filed and patent is being granted, if you want to know the legal status, you can check in this. I think net is very slow, but in that particular site only you will have a public search for trademarks also. You have for industrial design also, and you can see all this information. Okay, public search option in this particular site. Okay, if you want to look for patents, industrial design, GI, and also this trademarks. Okay, copyrights will it is not available. It is separate, and that in copyright boards. Okay, which is in Delhi. Okay, and we have an e-filing system where you can file online application. Okay, and you can also apply physically also going to the appropriate office. Okay, so for all the southern region we have to file through Chennai patent office. Okay, So this is
Can you just check the status of my application, madam?
yeah, tell me, sir.
2019